Good morning. I hereby call to order this 13th meeting of the Pennsylvania Public Utility Commission for the year 2017 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we start our meeting for today, we would be remiss if we did not acknowledge all the things that are going on in our country, especially in our southern border in Texas and Louisiana. Our thoughts and prayers go out to those affected by Hurricane Harvey. Working hard to restore power in the wake of hurricanes or other major disasters is a team effort, particularly after a historic storm like Hurricane Harvey, which has wreaked havoc in Texas and other parts of the Gulf Coast. We thank our utilities here in Pennsylvania for participating in the Mutual Aid Assistance Program and for their willingness to send crews and equipment when they are needed down there. We also want to acknowledge the work of our skilled emergency responders who have answered the call to assist the rescue and recovery efforts, including PEMA, the members of Pennsylvania's Urban Search and Rescue Team, the Pennsylvania Fish and Boat Commission, and the Pennsylvania Air National Guard. Finally, we appreciate the efforts of volunteers and other concerned citizens from across the state who are contributing their time and resources to help the victims of this devastating storm. Also, before we move on to our regular agenda, we have to acknowledge, the lonely heart sitting up here with the empty seat, have to acknowledge our former colleague, Commissioner Rob Powelson, FERC Commissioner Rob Powelson, who is in the house today, and I could tell when he came in because everyone started swarming over there by the doors. So we do welcome him for being here today, and I think he has April with him, or she was coming. Okay, well, we do welcome you here today. So our first matter on this morning's agenda is the minutes of the meeting of June 14, 2017, and I believe Vice Chairman Place is the editor.
Yes, Madam Chair, I've reviewed the minutes of the July 12, 2017 public meeting and move that they be accepted as submitted.
You have heard the motion to accept the minutes of June 12, 2017. Is there a second to the motion?
Second.
Second by Commissioner Sweet. Any discussions, any further edits? Hearing none, all those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 4-0. We will now move on to our agenda, and we ask for our Director of the Office of Special Assistance, Cheryl Walker Davis, to lead us through today's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items commencing this morning. With matters on behalf of the Commission's Bureau of Administration, it is recommended that the Commission adopt the various recommendations on pages 1 and 2 with regard to various assessments upon public utilities, as well as pipeline operators, in addition to electric generation suppliers and natural gas suppliers.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
With regard to matters presented on behalf of the Commission's Office of Special Assistance, commencing on page 3 of the public meeting agenda, we recommend the adoption of the items commencing with Najee Transportation, Inc. at the top of page 3 and continuing with the remaining item on page 3. The top item, Boaz Cab Corp. On page 4. It should be noted that the second item on page 4 pertaining to the Commission's Bureau of Investigation and Enforcement versus Bill Rawbash Charter Service, Inc. has been postponed until public meeting of September the 21st. The omnibus continues with all items on pages 5 and 6 through and including the joint petition seeking approval of interconnection agreement of Windstream D&E, Inc., Broadvox, CLEC, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
On behalf of the Commission's Bureau of Technical Utility Services, we recommend the adoption of the items commencing with the petition of UGI Utilities, Inc. at the top of page 7, pertaining to a waiver of the distribution system improvement charge cap, and continuing with the remaining 2 items on page 7, as well as the first 2 items through and including the matter labeled electric generation supplier license cancellations on page 8.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
It is recommended that the Commission adopt the staff recommendation with regard to the general increase filing of the Veolia Energy Philadelphia, Inc., noting the statement of Commissioner Coleman.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Under discussion, I recognize Commissioner Coleman for his statement.
Thank you, Chairman. As many of you know, we've had a staff change in my office. After 44 years of service to this commission, Rhonda Staver has retired, and we've gone through a recruitment and have hired Philip Kirshner. And many of you know Philip has worked in our Bureau of Investigation Enforcement as a prosecutor, so this morning I have a series of conflict statements on cases that he had worked on while he was with the Bureau of Investigation Enforcement. So I simply ask that my statement be entered in the record as though I had read it in its entirety. That prior to joining my staff, Philip Kirshner was an attorney in the Commission's Bureau of Investigation Enforcement, during which time he worked on this matter to avoid any impropriety arising from the potential conflict. I would like to note that I have not been advised by Philip on this proceeding. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
Continuing with the presentation of items on behalf of the Commission's Bureau of Technical Utility Services, it is recommended that the Commission adopt the staff recommendation appearing at the top of page 9 with regard to the application of Citizens Telecom Solutions, LLC, for expanded authority to offer and supply competitive local exchange carrier services. Continuing through the remaining items on pages 9, 10, 11, and 12 through and including the last item there appearing pertaining to the PPL Electric Utilities Corporation letter of notification.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
On behalf of the Law Bureau, it is recommended that the Commission adopt the various items appearing on page 13, commencing with that first item at the top pertaining to the People's Gas Company, People's TWP LLC, and continuing through the items on pages 13 and 14, concluding with the matter labeled as the proposed rulemaking for natural gas distribution company business practices, noting your statement, Madam Chairman, with regard to that item.
I propose that we take the first 3 items on page 13. So is there a motion to adopt the staff recommendations for the 3 items on page 13?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0. On page 14, as noted, is there a motion to adopt the staff recommendation on the proposed rulemaking?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Under discussion, I do have a statement I would like to place on the record in its entirety. Before the Commission is the advance notice of proposed rulemaking pertaining to the Commission's regulations at 52 PA Code Sections 62.225. This ANOPR proposes modifications to the matter and to the manner and protocol in which natural gas distribution companies recover the cost for capacity. Here, the Commission proposes to have NGDCs recover capacity costs for all customers, regardless of shopping status, on a non-bypassable basis. I encourage parties, to the extent interested, to comment on any potential implementation challenges that may arise from this proposal and any appropriate courses of action to overcome such implementation challenges. I am pleased to propose these steps as a continuation of the efforts commenced under the Commission's natural gas retail markets investigation. I'm cognizant these proposed changes represent a significant change to NGDC operations. As such, I support the use of the ANOPR process in an effort to thoroughly deliberate the proposals included in this proceeding, and I look forward to reviewing all comments. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
Turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, it is recommended that the Commission adopt ALJ Watson's recommended decision in the matter at the top of page 15 pertaining to the application of PennDOT.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet, who seemed to be louder than
I was
Commissioner
going
Copeland. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
With regard to the complaint proceeding of David Wapensky versus PPL Electric Utilities Corporation, there is your motion, Madam Chairman, as well as the statement of Commissioner Coleman.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet, and at this time I would turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I will submit my motion for the record in its entirety and read the general provisions for your hearing. By initial decision issued on January 3rd, 2017, ALJ Buckley dismissed the complaint with prejudice due to Mr. Wapensky's failure to prosecute. Because no hearing was convened, this dismissal is not applicable in my mind. If the hearing had been convened and if Mr. Wapensky had failed to appear, the motion to dismiss would be appropriately before us. I believe it is not. Instead, Mr. Wapensky's action should be deemed to be a request to withdraw his complaint. The grant of the withdrawal will be by tentative order. If no objection to the tentative order is filed by either party, the matter will be closed. If either party objects, the matter will be remanded to the Office of the Administrative Law Judge to continue the proceeding. Therefore, I move that 1, the ALJ's initial decision is reversed. 2, that the parties have 20 days to notify the Commission in writing whether they object to the case being withdrawn, and 3, the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Under discussion, I recognize Commissioner Coleman for the purposes of his statement.
Thank you, Vice Chairman. I'd ask that my statement be entered in the record as though I read it in its entirety. In this formal complaint, Mr. Wapensky requests a payment arrangement from PPL Electric Utility Corporation. Since April of 2012, Mr. Wapensky has filed 7 formal complaints against PPL while only making 6 payments for his electric service. Mr. Wapensky has previously defaulted on 45 prior payment arrangements from the company. Mr. Wapensky has not participated in this case since April 4th of 2016 when he dialed into the scheduled telephonic hearing and provided erroneous information to the administrative law judge. Since the complainant dialed into the appropriate number at the appropriate time, I am confident the service in this case was effective and proper. Between then and now, Mr. Wapensky appears to have done nothing in the matter that has responded to PPL's motion to dismiss or the decision of the ALJ despite ample time to do so. It is my belief that ALJ Buckley's decision to dismiss this matter with prejudice for failure to prosecute is correct. Accordingly, I do not support the proposed motion. Thank you, Vice Chairman.
Thank you very much. Any further discussion? Hearing none, all in support, please say aye.
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 Any opposed?
Opposed?
The motion carries 3-1. Thank you. The gavel is yours, Chairman.
On the matter as amended, any further discussion on the matter as amended? Hearing none, is there any objection to taking the previous roll call? Hearing no objection, The matter as amended passes 3-1, noting the dissent of Commissioner Coleman.
Turning now to page 16 at the top, it is recommended that the commission adopt ALJ Cavelli's initial decision in the matter involving the complaint of Patrick Kelly versus Philadelphia Gas Works, noting the statement of Commissioner Sweet.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? I will second it. So, motion by Vice Chairman Place, second by myself. Under discussion, I would recognize Commissioner Sweet.
Thank you, Madam Chair. This is a sort of a contorted set of facts, and I'll try to be as simple as possible in terms of my statement. The complainant challenges the amount of a bill issued by PGW for unbilled usage following the discovery of a meter bypass and lines installed before the meter at his residence. PGW terminated service and issued a bill for an estimate of over $21,000 of unauthorized, and I underscore unauthorized, usage for the duration of his service from 2003 to 2015. The ALJ adjusted the total estimated bill downward by approximately $3,000. This is downward. This is now in favor of the complainant, not PGW. Downward because it included a gas appliance that was only present in the residence for roughly the second half of that time period. I believe that the adjustment should be reversed because the commission is barred by the statute of limitations from granting relief for an action brought more than 3 years from the date the liability arose. Unfortunately, this issue was not raised by the parties, nor by the ALJ, but the statute of limitations is jurisdictional and cannot be waived and should not be ignored. As the decrease was for the years from 2003 to 2009, and the liability arose at the time of gas consumption, no reduction in the estimate is justified, and the complaint should be dismissed. I see no reason for this commission to reach beyond our lawful authority in order to give partial relief to this particular complainant. Accordingly, I'm dissenting in this matter
Thank you.
based upon the outcome of other discussions.
Thank you, Commissioner Sweet. Any further discussion? Hearing none.
I
Commissioner Coleman.
do have a statement to enter to the record this morning. I'm voting to affirm the ALJ's decision in this matter. The ALJ concluded that PGW's estimate in the amount owed by the customer was largely correct, but made an adjustment because the evidence appears to show that one of the gas appliances was not placed into service until a later date than PGW assumed, consistent with Commissioner Sweet's statement. PGW did not object to the complainant's evidence and did not file exception to the decision. While I share the displeasure with my colleagues and with the conduct of this customer, I believe that the evidentiary record requires that we affirm the ALJ's decision. Finally, I believe that the complaint was timely filed as it was submitted less than a year after PGW notified the customer of the dispute over the amount owed. This timing is well within the 3-year statute of limitations under the Public Utility Code and more than 30 years of precedence of this commission, so I will be voting to affirm the ALJ.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed.
The motion passes 3-1, noting the dissent of Commissioner Sweet.
It is recommended that the commission adopt ALJ Salapa's initial decision in the proceeding involving Hickory Hollow Farms CO Lamar Harnish versus Liberty Power Holdings LLC and Unified Energy Alliance LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
At the top of page 17, with regard to the complaint proceeding of Francine Kennedy Thomas versus Philadelphia Gas Works, there is your motion, Madam Chairman.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet, and I would turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I will submit my motion for the record in its entirety and read the focus on the main parts of the motion for your hearing. On September 9th, 2016, Francine Kennedy Thomas filed a formal complaint against PGW seeking service reconnection and a payment arrangement. All parties appeared at the scheduled telephonic hearing, but the complainant dropped off the call due to alleged phone problems. The complainant attempted to reschedule the hearing. However, on April 13, 2017, the ALJ denied the letter petition to reschedule the hearing because it was late filed. By initial decision issued May 4, 2017, the ALJ dismissed the complaint with prejudice for failure to prosecute. The Commission has long recognized the mitigating effect pro se status confers upon litigants unlearned in the law when confronted with technical violations of procedural rules. I believe that this pro se complainant made a good faith attempt to appear at the March 3, 2017 hearing, contacted the ALJ on the next business day following the hearing, and also made what appears to be a good faith attempt to timely file the letter petition requesting another hearing without the guidance of an explicitly stated letter petition due date. Consequently, this matter should be dismissed, but without prejudice. Therefore, I move that the ALJ's initial decision be modified consistent with this motion, and the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion? Hearing none. All those in favor signify by saying aye.
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 Any opposed? Motion carries 4-0. Gavel is yours, Chairman.
On this matter as amended by the motion, if there's no objection, we can take the previous roll call. Seeing none, the matter as amended passes 4-0.
It is recommended that the Commission adopt ALJ Long's recommended decision approving the settlement, the joint petition for settlement involving UGI Penn Natural Gas Company's general rate increase request, noting your statement, Madam Chairman, as well as the statement of Commissioner Coleman.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. For my statement, I will read it in its entirety because it is brief. Before the Commission is the recommended decision of Administrative Law Judge Mary D. Long in the matter pertaining to UGI Penn National Gas, Inc.'s proposed base rate increase. The RD approves a full settlement reached by all active parties. The settlement constitutes a reasonable body of terms that I believe is in the public interest. In particular, I am encouraged by the terms contained in paragraph 26 of the settlement, which permit UGI to capitalize the development costs for cloud-based information systems. This accounting treatment is wholly consistent with the resolution passed by the National Association of Regulatory Utility Commissioners related to the regulatory treatment of cloud computing arrangements. The information technology landscape is ever evolving. With its coming an equally significant evolution of the expectations of utility customers, it is the duty of commissioners to construct a regulatory climate which accommodates new technologies and capabilities in order to provide utilities with the tools necessary to satisfy and empower their customers. Permitting for the capitalization of cloud computing helps to align the interest of regulated utilities with the expectations of the 21st century customers. Nonetheless, the Commission will always maintain its steadfast obligation to ensure all costs embedded in rates, regardless of accounting treatment, are prudent. Any further comments? Commissioner Coleman.
Thank you, Chairman. This is another conflict statement consistent with what I mentioned earlier. Just ask that the statement be entered into the record as though I read it in its entirety. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
At the bottom of page 17, it is recommended that the Commission adopt ALJ Salapa's initial decision in the matter involving Andrew Kosman versus Pico Energy Company.
Is there a motion to adopt staff recommendation?
So moved.
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
Turning now to page 18, we will propose consideration of the first two items in tandem. It is recommended that the commission adopt both ALJ Watson's recommended decision approving the joint petition for settlement in the matter involving the Peoples Natural Gas Company LLC and Peoples Natural Gas Company LLC Equitable Division purchase gas cost filing, as well as ALJ Watson's recommended decision approving the joint petition for settlement in the matter involving the Peoples TW's P LLC purchase gas cost filing, noting the combined statement of Vice Chairman Place with regard to these items and these separate statements of Commissioner Coleman with regard to these items.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Sweet, second by Vice Chairman Place. Under discussion, I will call on Vice Chairman Place for his statement.
Thank you, Joan. Madam Secretary, I ask that my statement be entered into the record as if I'd read it in its entirety. Before the Commission for consideration and disposition is the purchase gas cost filings as required under Section 1307F for Peoples Natural Gas Company, Peoples Natural Gas Company Equitable Division, and Peoples TWP, which provide for projected changes in tariff rates resulting from changes in the company's purchase gas costs. On June 27, 2017, a joint petition for settlement was filed. I recommend approval of the PGC filings as amended by the settlement. However, while I am supportive of the settlement, I want to express my concern for the increasing levels of lost and unaccounted for gas. Specifically, LUF on the Peoples Equitable System has increased steadily from 3.79% to 4.44% to 5.54% respectively over the last 3 years. Similarly, LUF on TWP has increased steadily from 2.27% to 2.88% to 3.36% to 3.91% respectively over the last 4 years. Moreover, LUF has increased in absolute terms despite lower throughput in 2016 for all companies. The companies have been on notice for some time regarding these high loss factors. As more fully enumerated in my written statements, as far back as 2007, numerous commission statements have been issued expressing these concerns for each of the companies. Similarly, as also enumerated in my written statement, each company is committed to develop and implement numerous LUF reduction strategies as early as 2008. Under the current settlements before us, the companies propose to assemble a cross-functional team to assess, analyze, and to take deliberate steps to mitigate LUF. The team will be led by a new, senior, full-time manager with a primary job description of managing LUF activity. People's immediate plan is to continue the LUF reduction initiatives described in their filing, which the companies claim have proven over time to be effective. In addition, the companies have started a process to review the ongoing value of owning, operating, and maintaining various portions of its gathering system. Peoples plans to study the projected cost of owning and operating various segments of this gathering system in the future and to assess options, recognizing that while customers served directly from the gathering system comprise less than 1% of Peoples' total customer base, this is still a substantial number of customers, and even more are served from distribution systems connected to the gathering system. The company will prioritize enhanced leak repair, will continue to monitor supply interconnects to ensure accurate measurement and backflow prevention equipment is effective, and will continue system segmentation efforts to identify and report LUF based on pipeline function. However, Peoples reasons that it is not feasible to expect immediate and significant reductions in UFG as a result of UFG mitigation efforts. I am concerned by this reasoning. As stated above, many of these LUF reduction plans have been on the books since at least 2008, over a decade, as documented in the previous cases addressed by this commission. The companies have had sufficient time to explore the effectiveness of these strategies. I agree with the Office of Investigation and Enforcement and the Office of Small Business Advocate. It is time for People's UFG mitigation plan to show positive results. This is fundamentally important as the company's current LUF is not only costing customers upwards of $23.9 million per year, but also losing to the atmosphere substantial quantities of a potent greenhouse gas. In this proceeding, the companies were critical of both I&E and the OSBA for not proposing alternative solutions. To this end, I will point out that the utilities have strongly objected to this commission being a super board of directors. The commission, as well as utilities, have the tools to change policies that permit companies to operate efficiently and to reduce costs. If a policy change is needed concerning this issue, I'd encourage the companies to inform the commission and other stakeholders of needed improvements to address the UFG issue. However, in the interim, I suggest the companies empower this cross-functional team to immediately reduce LUF and reflect improvements before the company's next 1307F docket that otherwise might necessitate is not a good word to have in a statement, but there it is. 1307 docket that otherwise might necessitate an adjustment to disallow certain costs as were presented here. Thank you very much.
Thank you, Vice Chairman Place. Any further discussion? Hearing that, Commissioner Coleman.
I have
Apologize.
quite all right. I have conflict statements for both of these cases, similar to my earlier conflict statements, and just ask that they be entered in the record as though I read them in entirety. Thank you.
Thank you, Commissioner Coleman. Any further discussion?
Wouldn't dare.
All those in favor say aye.
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 Any opposed? The motion passes 4-0.
It is recommended that the commission adopt ALJ Salapa's initial decision in the matter involving Charles F. Jackson versus Pennsylvania Electric Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
With that concluding the presentation of regular agenda items, we now turn to the carrying agenda. It is recommended that the commission adopt, on behalf of the Office of Special Assistance with the concurrence of the Law Bureau, the recommendation in the matter involving Wenger Works, Inc., TA Tuk Lancaster, noting your statement, Madam Chairman.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman, and I would like to put a statement on the record in its entirety. In my statement issued at the July 12, 2017 public meeting, I indicated that I could not, in good conscience, approve this application based on the information that was before us at that time. On July 21st, 2017, Wenger Works, Inc., Tuk Lancaster, filed a petition for declaratory order seeking a determination that its proposed transportation services are exempt from commission regulation and that a certificate of public convenience is not necessary to provide services in connection with its sightseeing business. In its petition, Tuk Inc. presented information to answer questions I posed in my statement at that time. Just as important, the statutory process providing for this petition supplied another opportunity for Tuk to clarify the information in its application pertaining to the primary focus of its business. I would like to thank the company for providing essential information necessary to make an informed decision. As such, I agree with staff recommendation that the services provided by Tuk is not under our jurisdiction. Any further comments? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
Turning now to the supplemental carrying agenda, it is recommended that the commission adopt, on behalf of the Office of Special Assistance, the recommendation in the matter involving Robert M. Matu versus West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
And Madam Chairman and Commissioners, we have the motion of Commissioner Sweet with regard to the Commission's review of vegetation management practices.
I will call on Commissioner Sweet for his motion.
Thank you. I ask that my motion be placed upon the record as if I'd read it in its entirety. After a widespread power outage in 2003, Congress passed the Energy Policy Act of 2005, which authorized a new organization, the North American Electric Reliability Corporation, NERC, to act as the enforcer of new reliability standards, including mandatory vegetation clearance standards for electric transmission lines above 400 kilovolts kV, as well as any lower voltage lines which are designated as critical to reliability. Our electric distribution companies responded admirably and implemented plans to comply with these new standards. These new standards worked so well that the EDCs began using the new techniques on lower voltage lines without meaningful discussion with this commission. The vegetation management plans that the EDCs file every 2 years do comply with the requirements of the commission's regulations, but those requirements are vague and do not require as much detail as our neighboring states like Maryland and New Jersey require. We have seen where landowners with concerns regarding these practices on land underlying rights of way have no meaningful recourse because the EDC's plans are so lacking in detail that almost any vegetation management is consistent with the plans. In fact, I note that the matter just previously before us on our calendar was one such issue which generated significant disagreement among the commission members. With this motion, commission staff is directed to convene a collaborative of EDCs, public advocates, interested stakeholders, and commission staff to explore best practices and to determine a recommended course of action in regulating vegetation management. Therefore, I move, number one, that the Bureau of Technical Utility Services in conjunction with the Law Bureau, convene a collaborative within 30 days of the entry date of the Commission's order to discuss best industry practices and define common ground in matters of vegetation management. Two, that the Bureau of Technical Utility Services, in conjunction with the Law Bureau, prepare a recommendation for this Commission's consideration at a regularly scheduled public meeting, the next steps in the process of updating Commission oversight of vegetation management. And thirdly, that the Office of Special Assistants prepare an appropriate order. Thank you.
You have heard the motion of Commissioner Coleman. Is there a second to his motion?
Excuse me, it was.
I'm sorry. I apologize. Commissioner Sweet.
Oh, we switched.
I mean, you guys switch seats.
Moved seats on you, so. But probably not changed position.
I do apologize. Let me correct the record. You have heard the motion of Commissioner Sweet. Is there a second to his motion?
Second.
Second by Vice Chairman Place. Under discussion, Commissioner Coleman.
Thank you, Chairman. I'd ask that my statement be entered in the record as though I had read it in its entirety. I'm all for convening collaboratives and exploring vegetation management best practices and look forward to reviewing those results of this process. I'll give serious consideration to the results of the collaborative and any subsequent recommendations prepared by our staff. However, I don't agree with some of the commentary offered in support of this motion and the scope of the proposed review. I'm not ready to conclude at the beginning of this process that our regulations are flawed or inadequate. These regulations were subject to a robust review and approval process and enjoy the presumption of reasonableness as a matter of law. The issue that appears to be generating the most concern is the use of herbicides within the right-of-way. And as Commissioner Sweet has indicated, there was a lot of conversation on the previous case at a previous public meeting in which I appreciate the patience of the audience that we had a lot to say on this matter. The regulations of herbicides may in fact lie outside our jurisdiction, and it is well recognized that the Commission cannot resolve disputes involving the scope of easements established pursuant to private contracts. I don't believe it is wise to criticize our regulations or raise expectations about matters that may be powerless to change without legislation. Finally, I believe that the process we use to review and resolve disputes between utilities and customers is appropriate and should not be part of this proceeding. The Commission's statutorily prescribed complaint process has been and continues to be adequate to address challenges to vegetation management practices. Parties have a right to file a complaint and have a right to be heard on their complaint, which includes the right to an evidentiary hearing to resolve any disputes of material facts. Accordingly, I will be dissenting on this C motion. Thank you, Madam Chair.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 3-1, noting the dissent of Commissioner Coleman.
Madam Chairman and Commissioners, that does conclude the presentation of public meeting agenda items. Madam Chairman, I believe that you've got some ancillary comments.
Thank you very much. I do have some comments for the record before we close out on the Lifeline program. In coordination with a national effort to reach those in need of telephone and broadband assistance, the Public Utility Commission will recognize September 11th through the 17th as Lifeline Awareness Week. This recognition is in conjunction with the National Association of Regulatory Utility Commissioners. As part of our outreach, we are encouraging consumers across the state to understand the resources available through the Lifeline program, which is used by nearly 500,000 Pennsylvanians. Lifeline has now been expanded to include broadband internet services for low-income households, in addition to or in combination with landline or wireless voice telephone service. It is essential that consumers understand the expanded options now available, including a variety of voice and internet services. Additional information about Lifeline and other communications assistance programs, along with contact information for various telephone companies that participate in the Lifeline program, is available on our website. And that is it for our public meeting. Without objection, anyone want to give a motion to adjourn?
So moved.
Anyone want to get
Second.
a second? All those in favor to adjourn?
Aye.
The meeting is adjourned.